This is Kachka versus Kachka, and each side will have 15 minutes to present their arguments, and the appellant may reserve up to 5 minutes. So if you would just let me know if you would like to do so. And please don't mention the names of any minors or any children. We just refer to them as a minor or as their initials. And I also alert everybody to no victims. I know this is not a criminal case, but we just want to make sure that everyone knows we are being recorded and we're being live streamed as well, so that we just want to make sure everyone understands the rules. Okay, are we ready to proceed?
Yes, Your Honor.
Okay, would you like to reserve some time?
I would. I'd like to reserve 5 minutes.
That's fine. Thank you very much. You may proceed.
I may please the court. My name is Dennis Levin. I represent the appellant, Greg Kachka, in this matter. And this has to do primarily with a civil protection order that was issued. I guess we should probably touch on one of the issues, and that is whether or not, in this particular case, Mr. Kachka needed to file objections. Our position is that the magistrate was obligated to include in his magistrate's decision notification that the appellant had 14 days in which to file objections and some additional information. Unfortunately, the court didn't do that, and it's our position that as a result of that, we can take a direct appeal, which Mr. Kachka has done. I know that the appellee is contending that under Civil Rule 65-1, it's no longer required. Our position is that if you look at the language of Rule 65-1, it states specifically that as long the other rules still apply as long as they're not inconsistent. Well, 65-1 may supersede 53. It's just not eliminated in total. And in 53, there is that requirement. As a result, we have the right to appeal this directly to the court.
What about 9th District case law on that issue?
I'm sorry, what?
What about 9th District case law on that issue?
Well, I haven't found a case that is in exactly the same situation as this case. There are cases where the appellants took direct appeal, but I haven't found a case where the magistrate had not included the information that we believe needs to be included in the magistrate's decision.
Mr. Levine, we lost your video. Did you somehow turn it off? Oh, there you are. Okay, fine. Go ahead.
All right, I'm sorry.
That's okay. That's all right.
I'm not aware of a case where the magistrate had not included the information that was required. I don't know why I keep losing video.
I don't know either, but that's okay. We can still hear you, so.
Okay. Given such, our argument, the one I'm going to really talk about mostly is the issue of whether or not the appellee had demonstrated by preponderance of the evidence that the petitioner, that she was in danger of domestic violence, which is our assignment of error number 2. It's our position that the appellee failed to offer sufficient evidence to support the issue of a domestic violence civil protection order against the appellant. As this court is well aware, when assessing the sufficiency of the evidence for a trial court's decision to grant a civil protection order, the court must determine whether, viewing the evidence in the light most favored to the petitioner, that she demonstrated by preponderance of the evidence that a civil protection order should issue. In other words, the court must test the adequacy of the evidence as opposed to resolving the evidence conflicts or credibility of the witnesses. The judge and the trial magistrate in this case issued domestic violence protection orders based on the court's determination that the wife had established by a greater weight of the evidence that husband committed acts that constitute domestic violence as defined by Ohio statute. We believe that the evidence is weak and far and certainly not sufficient to warrant the issuance of the order in this case. There were I think about 5 things that the appellee testified to at trial, and many of those didn't even apply to her. I'm assuming that the court has read and knows the facts of this case. The first thing that she talked about was that she was afraid of violence based on the fact that the appellant gave her money and instructed her to use it to buy groceries. I don't see how that's in any way it would be reasonable to infer that you are in danger of violence based on the fact that somebody gives you money and tells you to use it to buy food for the family. Her second issue was that if she wore certain clothes, he would get angry and call her some names. Again, there's no evidence of any violence, no evidence that she was ever in danger of violence or of any kind of injury. The next thing that she talked about was at one point, I think it was right before she left the house, he picked her up and put her on the bed and said to her something to the effect that he'd like to maintain a sexual relationship with her even after their divorce. She said no. I think he patted her on the butt, and that was the end of it. Everybody went their separate ways. Again, there's no indication of violence, no indication of any serious physical harm.
Well, Mr. Levine, my understanding is he didn't just place her on the bed. He pretty much slam dunked her on the bed.
Well, I think it says he picked her up and placed her on the bed. I don't think there was any indication that there was any violence involved. And again, it was, he was talking to her about maintaining a sexual relationship. She said no. That was the end of it. He left. There's no violence, no reason to be fearful of violence at that point.
Isn't the question whether a reasonable person would be placed in fear of imminent serious physical harm?
That's correct.
Necessarily have to.
That's correct. But the question is, would it be reasonable based on these incidents to believe that you're in fear, that you should be in fear of serious physical harm? In this case, you've got someone giving you money and telling you to use it to buy groceries. I don't see where any reasonable fear of physical harm can be found from that. The issue with the clothing, again, she said that it had been ongoing. She had never made any complaints about any physical harm. In fact, I think she testified there was never any threat or physical harm involved with the clothing she was wearing. Mm-hmm. In fact, I think if you look at the record, there is nothing to indicate that he ever, through the entire marriage, did anything to cause her any kind of physical harm. There just isn't. And there's nothing from the other evidence that she presented that would indicate that she had reason to be fearful of physical harm. The other 2 incidents that she testified about both involved the children and not her. I think there was one where he hit his hand against the wall in the basement, put a hole in the wall. Again, that's not indication of physical harm. That doesn't indicate that she should be, that it's reasonable for her to believe that she should be in fear. In fact, it shows more of an ability to control himself, because he didn't strike out against any individual. He hit the wall with his own hand. He hurt himself, I'm sure. And like I said, the other 2 incidents involved taking one of the kids who was acting up, I guess, into the shower. And while wife called it waterboarding, it was nothing more than putting the child under the shower to try and calm him down. And the last one, again, was involving the children. And that was trying to calm the other child down by holding him down.
She also testified concerning a pattern of conduct or pattern of stalking, for want of a better word.
I'm sorry, I couldn't hear you. A pattern of.
She also testified that, she also testified about a pattern of stalking
Yeah, her pattern of stalking was she claimed that he came to the apartment that she moved to try and see the kids. And she knew he was coming and left and took off and went to a friend's house. I mean, that's all the only stalking I can see from the record. There just isn't sufficient evidence to warrant the granting of a civil protection order in this case. And if the court looks at other cases that it's overturned in this district, you see, this case doesn't even come up to most of the incidents that took place in those cases.
But wouldn't her testimony that he forced himself upon her when it's uncontroverted? In other words, there was no evidence contrary to that. The court making the determination as to who to believe, credibility of witnesses, together with that presumption. Why would that not be enough?
Well, I don't believe that there was any. I don't recall any testimony that he ever forced himself on her. I think that there was testimony that they did have a sexual relationship, but I don't think there was ever anything regarding forcing himself on her. And, the stalking, I just don't see where there's stalking in this case, where he was going to try and see his kids and make sure that they were safe and comfortable. I mean,
Mr. Levine, you're starting your rebuttal time. Do you want to save those 5 minutes or proceed?
I will save the
Okay,
5
thank
minutes.
you. Mm-hmm. All right, Ms. Eubanks, you have 15 minutes.
Good morning. I am
Good morning.
Renee Eubanks. I represent the appellee, Ashley Kachka. We are here because the appellant is seeking a second bite at the apple. His trial strategy did not achieve his desired results, so he's asking this court to give him a second chance. He failed to file objections, excuse me, to the trial court's decision. This court has, and in cases from Medina County, has held that the requirement in 65.1 that you file objections is mandatory, not discretionary. This court has held in civil protection order cases that the failure to file objections with regard to the granting or denial of the civil protection order does not permit the considering of a party's arguments on appeal.
But he's saying here that they never got any notice.
I believe that they did. And I also believe that the issue of whether or not that the Supreme Court forms are acceptable has been resolved. The appellant was not pro se. He was represented by an attorney through the entire process. The errors that the appellant is raising on appeal are primarily invited. He, during the trial, did not object to any of the magistrate's instructions or rulings with regard to his Fifth Amendment rights, and he wants to raise those issues on appeal for the first time also. The appellant did not present any evidence. He did not testify. He did not have other witnesses testify. He did not submit any exhibits, have any exhibits admitted. He and his attorney decided that he was going to take the Fifth Amendment. The attorney properly asserted the privilege for him. The trial court instructed that they were going to accept that as a blanket privilege. The appellant did not object. I tried to ask questions. He did not answer. Again, he didn't object to anything. Ms. Kachka's testimony is the only evidence on the record. Her testimony is that when she was leaving the relationship, which is the most dangerous time, the appellant is attempting to pursue sex with her. He is groping her. He picks her up. He throws her on the bed. She's afraid that he's going to force himself on her. She tells him, I don't want to do that. He says, I don't care if we get divorced. We are still going to have sex. He then follows her to her apartment when she says, I don't want you to come there. She's fearful, so she leaves and goes to a friend's. He sends the police to her apartment. She also testified that this was not the first round of the appellant doing this. When she tried to leave him before, a similar pattern of behavior happened. The court granted the civil protection order on two grounds. One, that she was in fear of physical harm, and 2, that he engaged in a pattern of conduct that he knew or should have known would place her in fear of physical harm. And Ms. Kachka's credibility, how she appeared, how she testified, those are questions for the trial court. That's evidence that has to be viewed in the light most favorable to her. The appellant is essentially arguing that this court should substitute its judgment for the trial court, and that's not what the law says is proper. The appellant has failed to follow the rules of civil procedure. He's failed to present any evidence, and his request for a second chance should be denied. Ms. Kachka asks that you leave her civil protection order in place. Thank you.
Thank you. Any questions? Okay, then, Mr. Levine, you have 5 minutes remaining.
Thank you, Judge. I would say to the court that every appeal is more or less a request for a second chance, I guess. Otherwise, you wouldn't be appealing. We're not asking for a second chance. We're asking for a first chance for the court to consider what's proper in this situation. Despite what counsel says about the threat, about the having sexual relations after the divorce, if the court reads the transcript, it's clear that it's not a threat. It was a request. It was a simple, would you consider having engaging in sexual relations even after we're divorced? There's nothing to be afraid of from that. There's nothing that he said that would give her cause to have fear of any kind of violence perpetrated upon her. I'd submit to the court that the evidence in this case is woefully lacking. Even if the court applies an adverse inference, it can't just make up evidence to fill in the holes. The most the court can do is determine that what the wife testified to was truthful, but that doesn't correct the problem that the evidence provided was insufficient. And doubling that insufficiency still renders the issuance of the CPO improper in this case. We're asking the court to dismiss the CPO and grant the remedy we've requested in our appeal.
Thank you. Thank you both for your arguments, presentations today. We will take the matter under advisement and will issue a written opinion that will be sent to both sides, as well as the fact that you can look on our website and the Supreme Court website for when it's released electronically. Thank you very much. It looks like it's sunny